In this video, we're going to be addressing a bunch of more issues as we continue studying about patents, and we're going to learn in this video who could challenge a patent. So first, there are two different ideas of interference and interviews. Interference is a proceeding that happens between two applications or an application and a patent, but it can't be between two patents, and it's to decide who's entitled to claims that both want to seek in their patent. And second, an interview is a personal meeting with the patent examiner, and they're easy to get before the final rejections. However, you still need written responses, and the lawyer is still going to be required to take down the contents of the meeting. And they're going to be expected to record the substance and present the arguments. Next, you have maintenance fees on your patents. So every 3.5, 7.5, and 11.5 years, you're going to be paying a maintenance fee. You have a 6-month leeway where you could pay it in advance or you could pay it late. But if you do it late, you're going to result in a surcharge. And if you miss it unintentionally, you're going to be allowed to revive your patent. But if you don't pay it and then it expires, that's it. It's done. Next, if your patent is rejected because of the obviousness, you're going to have to make the argument that a person of ordinary skill would not make this, or you're going to argue that the resulting combination is not the claimed invention in your patent application. You have two concepts of inventorship and ownership. Inventorship can never change, and an inventor is considered if they contribute to the conception. If they contribute to the reduction in practice, they're not considered a joint inventor, and they're never able to change. However, ownership is allowed to be changed. It could be sold, assigned, etc. In order to speed up the process, you're going to be able to file a special petition, and it's going to be making your patent process go quicker. You used to, in the past, be able to do it because of illness, environment, energy, or age, and you would have to pay if you were a prospective manufacturer, if there was infringement, if you had to wait for safer DNA for the asking, you were HIV, AIDS, and cancer research, or you were biotech. Now it's a more complicated process that we'll cover in a later video. Plant patents, they have two requirements: that the plants must be cultivated and they have to be able to reproduce asexually, i.e. not with seeds by themselves. And all plants are going to be patentable except for bacteria, which are not plants, and tuber-propagated plants such as potatoes. However, in regards to the reproducing asexually, you can reproduce them asexually, and then seeds afterwards. That's going to be fine. Who's going to be allowed to challenge a patent? Anyone. However, they're going to need to timely serve the person whose patent application it is, and they're going to have to serve the applicant. And in addition, there's no fee is going to be required for that. Lastly, there's a concept called the small entity status, where if you're a small entity, you get a discount. There are 3 different categories of small entities, where it's an independent investor who keeps the rights small, if you're a nonprofit or a university, or if you're a small business with less than 500 employees. And you have 3 months after you file to still claim the small entity status. And there's also other statuses. If you don't do anything, by default, you're going to be a large entity status. Thank you guys, and have a great day.